This hearing opens with the defendant already standing on the edge of a serious probation violation case, but things escalate almost immediately. What starts as a routine court update quickly turns into a layered situation involving multiple new criminal charges, alleged domestic violence, and interference with communications. The probation officer is now asking the court to revoke his freedom entirely. But here's the tension. Defense argues there's more to the story, including employment, personal struggles, and even claims from the alleged victim herself. As the courtroom unfolds, one question becomes unavoidable. Is this a case of repeated violations, or a situation being misunderstood under pressure?
2024, he is on bench warrant status in that case. Given that there has been continued alleged assaultive behavior with the added victim in this case, because the court did add a no contact with that victim, it does make it a violation of this case. Probation's asking that the court, one, address the felony warrant on that 2-4-FB case, if the court does have it, that the court revoke probation and sentence Mr. Carter to jail 365 days, credit for 162 days served to serve the balance, that he complete the jail DB program, waive remaining terms, accepting his financial obligations, and discharge him from probation without improvement.
Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case. However,
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know.
At this point, the legal situation becomes significantly more serious. The court is not only dealing with probation violation, but also newly filed charges, including a felony-level interference with electronic communication and a second offense domestic violence allegation. Legally speaking, this changes everything, because new charges while on probation signal potential escalation rather than rehabilitation. Probation's recommendation for revocation reflects that concern, asking for a 365-day jail sentence with credit for time served. The judge is now required to balance presumption of innocence on new charges with the risk posed by continued alleged conduct. This is where courtroom decisions become complex, because it's no longer just about past behavior, but ongoing risk assessment. Do you think probation should automatically be revoked when new charges appear, or should courts wait for full trial outcomes?
Case. You want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon, and obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was unfortunately he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before. Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. I understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October the 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they have contact with the police officer and admitted to having contact with the victim. denied the assaultive behavior, but did admit
As it
to
relates
having
to her
contact
phone, right?
with her. Now, because the
The return
defendant,
of the phone, right?
because the
Hey, the courtroom tension intensifies as both sides present completely different narratives. The defense argues that the defendant is employed, trying to stabilize his life, and may lose his job if detained. They also claim the alleged victim has communicated a reluctance to proceed with the case. But the prosecution strongly pushes back, pointing out a critical detail. The defendant was already under a strict no-contact order with the same individual when the alleged new offense occurred. That alone carries serious legal weight, because violating a court order directly undermines judicial authority. Even if contact seems minor or disputed, courts treat no-contact violations as high-risk behavior. This raises a bigger issue. How much should alleged victim cooperation influence a case when a protective order has already been issued? And does intent matter if the order itself was violated?
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand they're only allegations, but try to give you the darn benefit of the doubt regarding everything, because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't. But
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Simpson, can I say something?
You can say whatever you want.
I understand. She put up on me. I was in the room playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have of all rights locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all.
The judge ultimately delivers a decisive ruling, revoking probation entirely. The defendant is sentenced to 365 days in jail, with credit for 62 days already served, and required to complete a jail-based rehabilitation program, including domestic violence intervention. Legally, this means prior probation opportunities are terminated, and the court is now shifting from correctional supervision to full incarceration. The judge makes it clear repeated violations, missed chances, and continued alleged contact left no room for leniency. What stands out most is the judge's frustration, describing a cycle of behavior where previous warnings, reduced penalties, and opportunities did not lead to lasting change. This case ultimately highlights a key legal principle. Probation is not unlimited forgiveness, it's conditional freedom. one's conditions are repeatedly broken, courts are left with little choice but to enforce custodial sentences. If you found this case as intense as we did, make sure to hit the like button, share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns like this.
Young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
And Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. So if you just requested DV, court want the defendant to perform both or just one or the other?
I should have said in-jail DV program. Is what I meant to say. Thank you. Defendant's remanded.
Okay.